Women should have had the same right as men had in the 19th century. Women can do things for themselves like fighting for their freedom and equality. Women could do whatever their husbands can do. The various Property Act laws of the 19th century were the keystone of the women's rights movement. These acts acknowledging a woman's right to own property paved the way for all other rights such as women's suffrage. The Women's Property Act is where the women were considered to be possessions of their husbands and had no control over their money or property. The Women's Property Act fixed that and then had women being able to have possessions over themselves and had control over their money and property. Abigail Adams was one of the first advocates of Women's Property Acts. Adams believed that women should take more part in decisions rather than serving their husbands. Adams wrote a letter to her husband John in March 1776 when he was in Philadelphia. Adams wrote, "Remember the ladies, and be more generous and favorable to them than your ancestors. Do not put such unlimited power into the hands of the husband. Remember, all men would be tyrants if they could. If particular care and attention is not brought to the ladies, we are determined to form a rebellion and will not hold ourselves bound by any laws in which we have no voice or representation." Millicent Fawcett had her purse snatched by a youth in London. When the boy's crime was read out in court, Fawcett was surprised to hear him charged with stealing a purse, which was the property of Henry Fawcett, also known as her husband. She recalled that she had felt she had been charged with theft herself. The women of the Kensington Society and of the Langham Place group, of which Fawcett was a member along with others, campaigned for a change in the law to allow women to retain their own property and money after marriage. A married women's committee was formed to help this cause. Married women in the American colonies and later in the United States, women had barely any legal assistance apart from their husbands. Their rights and obligations were incorporated under their husbands. They were unable to own property, enter into contracts, and earn their own salary. Beginning in 1839, statutes enabling women to control real and personal property, participate in contracts and lawsuits, inherit independently of their husbands, work for a salary, and write wills were enacted in a fragmentary way, motivated by concerns of family honor and protecting a household from economic crisis more than by a liberal conception of the role of women in society. As late as 1867, a decision of the Supreme Court of Illinois in Cole v. Van Riper noted that it is simply impossible that a married woman should be able to control and enjoy her property as if she were sole, without practically leaving her at liberty to annul the marriage. The legislation came in 3 phases: permitting married women to own property, to keep their income, then to engage in business and advance more quickly in the West, just as female suffrage did. Connecticut's law of 1809 allowing a married woman to write a will was important, though its impact on property and contracts was so little that it's not counted as the first statute to address married women's property acts. Parents that gave property to their daughter upon marriage also enjoyed the protection the act provided from a son-in-law's mishandling of his family affairs. Any attempt to collect debt from her husband could not reach property only she owned. She had the right to refuse to sell property, but could not manage that property or sell it without her husband's consent. The property a woman could own and protect from her husband's investors included slaves. Several southern states implemented similar legislation, beginning with Maryland in 1843 and Arkansas in 1846. Beginning in the 19th century, women in the northern states were the principal advocates of enhancing women property rights, but the first legislation exemplifying some of the changes they advocated was enacted in the American South. Northern states that acted included Michigan in 1844, which covered both real and personal property obtained by a woman before or during her marriage. More limited statutes were passed in the next 2 years by Ohio, Indiana, and Iowa. Texas, still an independent republic rather than a state, passed its act in 1840. It was the most expansive legislation of any enacted in the South and allowed a married woman to enter into certain contracts, write a will, and sue for divorce. Not only could she reject the sale of her property, but she could reject the sale of the family homestead even if she was not its owner. Without referencing the independence of the wife that advocates for such legislation envisioned, legislators fought that the legislation protected the wife and children from irresponsible husbands. The original state constitutions of Kansas, Nevada, and Oregon, the right of women to own property without respect to married status. In 1845, New York granted a married woman who secured a patent for her own invention, the right to hold it and retain all earnings from it as if unmarried. It enacted its Married Women's Property Act on April 7, 1848. as part of a more general movement underway since the 1820s away from common law traditions in favor of the codification of law. Ernest and Rose had been campaigning for such a statute since 1836, later joined by Paulina Wright Davis and Elizabeth Cady Stanton. It significantly altered the law regarding the property rights granted to married women, allowing them to own and control their own property. It was used as a model by several other states in the 1850s. It provided that the real and personal property of any woman who may hereafter marry, in which she shall know at the time of marriage, and the rent issues and profits thereof shall not be subject to the disposal of her husband, nor be liable for his debts, and shall continue her sole and separate property as if she were a single female. The real and personal property in the rent issues and profits thereof any woman now married shall not be subject to the disposal of her husband, but shall be her sole and separate property as if she were a single female, except so far by the same may be liable for the debts of her husband heretofore contracted. It should be lawful to any married woman to receive by gift, by grant, advice, or bequest from any person other than her husband, and hold to her sole and separate use, as if she were a single woman. Real and personal property in the rent issues and profits thereof, and the same shall not be subject to the disposal of her husband, nor be liable for his debts. All contracts made between people in contemplation of marriage shall remain in full force after such marriage takes place. Pennsylvania had similar legislation a few weeks later. In July, the very first assembly of women's rights advocates, the Seneca Falls Convention, approved a declaration of sentiments, journalist by Elizabeth Cady Stanton, that listed among the injuries usurpations on the part of man toward woman. The movement to expand the property rights of married women did not go unchallenged. Virginia debated and rejected such legislation in the 1840s. In 1849, the Tennessee legislature stated in one historian's account that married women lack independent souls and therefore should be unable to own property. It then repealed parts of its legislation in 1862, eliminating a married woman's right to guardianship of her children and the right to a widow to manage her late husband's estate. Massachusetts passed its Married Women's Property Act on May 5, 1855. It allowed married women to own and sell real and personal property, control their own earnings, and make wills. As of 1860, 14 states had passed some version of Married Women's Property Act. By the end of the Civil War, 29 states had passed some version of the Married Women's Property Act. Harriet Beecher Stowe campaigned in 1869 for the expansion of married women's rights, arguing that the position of a married woman is in many respects precisely similar to that of the black slave. She can make no contract and hold no property. Whatever she inherits or earns becomes at that moment the property of her husband, though he acquired a fortune through her, or though she earn a fortune through her talents. He is the sole master of it, and she cannot draw a penny. In the English common law, a married woman is nothing at all. She passes out of legal existence. New Jersey passed a limited statute in 1852, and in 1884 a different version of that one historian described as comprehensive and progressive. The changing statutes and differences among states complicated the situation of female authors. A married woman's right to contract with a publisher and to control what her writings earned depended on the state and where her husband and she lived. As of 1887, 1/3 of the states had not provided protection for a married woman to control her earnings. Delaware, South Carolina, and Virginia gave no legal status to women until the late 19th century. In an exception to the statutory expansion of the legal right of married women, the California Constitution of 1849, drawing up the community property tradition of Spanish Civil War rather than the common law tradition, distinguished a wife's property from community property. All property, both real and personal, of the wife, owner or claimed by her before marriage, and acquired afterward by gift, devise, or descent, shall be her separate property, and law shall be passed more clearly defining the right of the wife as relation as well to her separate property, as to that held in common with her husband.